Today, the Supreme Court of Georgia ordered the removal of a judge for misconduct. We are going to take a look at that ruling and see some of the things that the Supreme Court says about ex parte meetings and communication violations, as well as some issues of holding people in contempt for the maximum allowable length of time. Let's look at what happened and see how that relates to what's going on in the YSL trial and Judge Glanville. The Supreme Court of Georgia has ordered the removal of Judge Christina Peterson, who was a judge in Douglas County, Georgia. Her name has been in headlines all week, and her body cam footage all over YouTube following an incident at a Buckhead nightclub. Now, with this recent arrest, she's facing simple battery against a police officer and felony willful obstruction of law enforcement by use of threats of violence. Now, that criminal action is still underway, and there's no convictions at this time. That all has to play out. But with this Supreme Court decision ordering for the removal of Judge Christina Peterson, which came down dated today, June 25th, 2024, there's a whole slew of other issues separate from this arrest that made all the headlines. And I would argue that a lot of these other things could be a lot more egregious. In this inquiry, the Supreme Court had to consider a number of violations of the Code of Judicial Conduct, including a number of violations that the Judicial Qualifications Commission says exhibited a pattern of judicial misconduct while in office. So these inquiries have been going on for quite some time, long before this viral body cam police altercation incident took place. Since being elected as Douglas County's probate judge in 2020, Peterson has been accused of ethical misconduct, totaling 50 charges. However, 20 of them have actually been dismissed. She is one of the highest paid, or was one of the highest paid judges in Georgia. And though we're getting the removal for her order from the Supreme Court today, Judge Peterson also lost the Democratic vote in the Georgia primaries on May 21st. So the news that's coming down today about this decision means that she is not even going to be finishing her term through the end of the year. But just so we get a timeline of how these things play out, through all of these different allegations that have stemmed from 2021, the filing that we're looking at on the screen is from March 31st, 2024, so just a couple months ago. And this is their report and recommendation that they sent forward to the Supreme Court of Georgia. But look at the time frames here, how long this process has taken. On the 21st of September 2021, the Director of the Judicial Commission's Qualification, we're going to call that JQC, filed formal charges against Respondent Judge Christina J. Peterson. After amending the charges and withdrawing or dismissing certain allegations, the Director now asserts 30 counts of misconduct arising from Respondent's alleged violations of the Georgia Code of Judicial Conduct. These 30 counts relate to 10 episodes of alleged misconduct: social media posts, improper contact with represented parties during litigation, violating courthouse security protocols to conduct a wedding, obstructing access to public court records, abusive interactions with a fellow judge and other county officials, holding a pro se litigant in contempt and imposing the maximum term of incarceration upon her, 7 and 8, exhibiting judicial incompetence, administrative mismanagement, and indifference relating to a petition for a year's support and letters of administration, routine backdating of orders, and systemic judicial incompetence. Now, some of these complaints relating to social media are a little bit relevant to this Buckhead incident. So here we see Wine Bottle Wednesday post. On the 9th of November 2020, Respondent posted to her Instagram account a solicitation for Wine Bottle Wednesdays, an event at a Tribeca lounge in Atlanta. As with the Rose Bar post, the flyer featured a large image of Respondent. Respondent's post read, "See you Wednesday, come party with me, Judge-elect CJ. The flyer for the event Respondent was promoting contained prices for food and alcohol and provided a link for reserving a table at the lounge. The event was highlighted as the hashtag Judge Edition. Respondent admitted that she advertised that she was a judge in order to get people to come. So that's why you're saying you're not really supposed to do stuff like that. Another claim takes us over to Twitter, where, with the handle @LoveChristinaJ, to post a purportedly satirical video that Respondent filmed, in which she admonished another character for being duped by a philanderer named DeAndre, with whom the other character had been intimate. Respondent warned that the other character needed to, quote, get rid of DeAndre because he was a homeless sexual, who, quote, says he's in love with you and wants to give you that good peen that y'all say those black guys got. That man will do anything for a place to stay. Now, this was made available while she was running as a candidate. So again, we're looking all the way back at 2021, since complaints started rolling in, to the point where even the Georgia Supreme Court back then was like, no, we're not even going to suspend Judge Christina Peterson. 2 years later, now they're ordering for a full removal. She can't be reelected for a period of 7 years. If we go back over to the Supreme Court of Georgia decision, this is 82 pages long. I'll put the link to the full 80-page document in the description if you want to read it in full. We're going to look at an interesting part that I want to show you. But just so you can get a top-level summary if you don't want to stick around, The Supreme Court says that we agree that removal is warranted here. Accordingly, it is ordered that Judge Christina Peterson of the Douglas County Probate Court be removed from office, effective upon the date of this opinion. So that's right now, today, instantly. As a result, Judge Peterson shall not be eligible to be elected or appointed to any judicial office in the state until 7 years have elapsed from the date of this opinion. So why does the Supreme Court of Georgia agree that removal is warranted here? And again, it has nothing to do with these charges that erupted this last week and a half. Well, as we explain more below, the hearing panel that was conducted by the Judicial Qualifications Commission found that the director proved by clear and convincing evidence 28 of 30 counts alleging that Judge Peterson violated the Code of Judicial Conduct, and that discipline is authorized under the Georgia Constitution for 20 of those 28 counts. With respect to all 20 of those counts, we conclude that the hearing panel's findings are not clearly erroneous, and we agree with and affirm the hearing panel's conclusion that Judge Peterson's misconduct warrants discipline with respect to 12 of them, because the director met her burden of showing that Judge Peterson's conduct constituted willful misconduct in office or conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. The seriousness of certain of those violations, the pattern of misconduct the director proved by clear and convincing evidence, and the adverse demeanor and credibility determinations the hearing panel made after observing live testimony from Judge Peterson all contribute to the conclusion we reached today. Now we're going to go through some highlights here. So let's do bullet points. So in June 2020, she won a contested primary election, and then she won the general election, which she ran unopposed, and was sworn in for a 4-year term. In September of 2021, the JQC filed formal charges against Judge Peterson, alleging several violations of the Code of Judicial Conduct. They amended these charges in February 2022 and again in July 2022, alleging 50 counts of misconduct. JQC ended up dismissing 20 of those counts before and during the final hearing, which was held over the course of 7 days in September of 2023. So that left 30 counts remaining for the hearing panel's resolution. The hearing panel then issues a report and recommendation on March 31st, 2024, which they give over to the Supreme Court of Georgia. And it's their opinion, their finding, that the director had proven 28 of the 30 counts by clear and convincing evidence, but that discipline was authorized pursuant to the Georgia Constitution for only 20 of those counts. Judge Peterson tried to file a notice of exceptions to the report and recommendation, arguing that the director had not sufficiently proven that she committed sanctionable conduct, and the director filed a response to those exceptions. So now, what's the court's analysis? What's the Supreme Court's analysis of all of this? They agree with and affirm the hearing panel's conclusion that Judge Peterson's misconduct with respect to 12 of the 20 counts at issue were proven by clear and convincing evidence and warrants discipline. Those 12 counts relate to 4 matters, which include Judge Peterson's handling of a criminal contempt matter, certain aspects of her conduct towards county personnel, her conduct during a meeting of her neighborhood's homeowners association, and her handling of a petition for years support. Now, what I really want to talk about is this incident 4, handling of a petition for years support, which related to counts 35 and 37 to 43. So 7 counts total. What happened here? Well, in early 2021, a petitioner filed a petition for years support, seeking to obtain funds from her deceased husband's estate. The petition listed the petitioner's daughter as an interested party and provided her out-of-state address. Judge Peterson's chief clerk sent by certified mail, with restricted delivery, a notice of the petition to the address that was provided for the daughter. The notice set the deadline to submit a caveat to the petition by May 3rd, 2021. On April 5th, 2021, the signature card for the certified delivery of the notice of the petition was returned to the probate court with a signature from someone else, not the daughter. Judge Peterson's chief clerk then asked Judge Peterson to search LexisNexis to try to obtain an alternate address for the daughter. Judge Peterson conducted the search and found the daughter's email address. Judge Peterson's chief clerk emailed a second notice to the daughter, setting a new deadline to file a caveat by July 10th, 2021. The daughter eventually emailed her caveat to the probate court's clerk's office. The chief clerk and the daughter then spoke by phone, and the chief clerk asked about the status of the original document and the filing fee, which were both required for the filing. The daughter said that she mailed the filing fee. The chief clerk assumed that it was lost in the mail and ultimately took payment from the daughter over the phone and filed the caveat on July 14th, 2021, 4 days after the July 10th deadline. None of the chief clerk's communications with the daughter included counsel for the petitioner. The hearing panel found that although Judge Peterson's staff, including the chief clerk, knew that ex parte communications with parties to a proceeding were prohibited, Judge Peterson, quote, clearly failed to conduct proper oversight to ensure that the chief clerk was not participating in such communications. The petitioner's counselor filed a motion to strike the caveat as untimely, and Judge Peterson denied it. Judge Peterson later recused herself from the case, which was eventually transferred to a Douglas County Superior Court. That court struck the caveat as untimely and granted the petition for year support, about 15 months after it was first filed. And the Supreme Court affirms that this record supports the findings. The Supreme Court also agrees with the hearing panel that the director proved by clear and convincing evidence that Judge Peterson violated the Code of Judicial Conduct in connection with her handling of the petition for year support. And look, we have Rule 2.9. All about ex parte communications, that rule we've read over and over in the YSL Judge Glanville shenanigans. So what does the Supreme Court think about the alleged Rule 2.9 violations? By accepting and considering the daughter's emailed caveat, of which the petitioner and her counsel had no notice, Judge Peterson permitted and considered ex parte communications in violation of Rule 2.9. And as the hearing panel noted in its report and recommendation, none of the exceptions listed in Rule 2.9 that might authorize ex parte communications applied here. By failing promptly to notify the petitioner's counsel of the second notice of the petition that was sent to the daughter by email, with the extended deadline for filing a caveat, Judge Peterson violated Rule 2.9. And by failing to provide proper oversight of her own chief clerk, who sent the daughter the second notice of the petition and spoke to the daughter on the phone about the case without notifying the petitioner's counsel of the communications, Judge Peterson violated Rule 2.9 because she failed to make reasonable efforts, including providing appropriate supervision, to ensure that Rule 2.9 is not violated by court staff, court officials, and others subject to the judge's direction and control. Accordingly, Judge Peterson violated each of the provisions of Rule 2.9 noted above. And they include this comment from Rule 2.9 that impending matters and pending proceedings are only as good as the parties make them. Neutral and detached, impartial judges should not be concerned about augmenting cases. Now, the hearing panel also concluded that Judge Peterson violated the Code of Judicial Conduct, Rule 1.1, by failing to comply with Uniform Probate Court Rule 5.1, which generally prohibits judges from initiating or considering ex parte communications with parties to a pending proceeding. The hearing panel determined that Judge Peterson also violated Rule 1.2 because permitting and sending communications to only one of the interested parties in the case diminishes public confidence in the independence, integrity, and impartiality of the judiciary, and weakens the public's perception that the judge has afforded all of the parties the same right to be heard. We agree with the hearing panel's determinations in this regard. I want to go back up to this footnote. Judge Peterson argues in her exceptions that the ex parte communications were permissible because they were made in an effort to perfect service, but her attempts to ensure that the daughter had notice of the proceedings, even if undertaken in good faith, do not excuse her failure to provide the same sort of notice to the petitioner. So this decision keeps reading that Judge Peterson was acting in her judicial capacity in handling the petition and in directing or supervising her staff. And two, as the hearing panel noted, even if Judge Peterson did not intend to favor one party over another, engaging in ex parte communications is inappropriate and unjudicial. So they agree. So the Supreme Court agrees, because engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with the party in order to unfairly advance that party's interests, and also jeopardizes the appearance of the independence, the integrity, and impartiality of the judiciary. So because Judge Peterson's inappropriate actions taken in her judicial capacity, even if undertaken in good faith, appeared to be unjudicial and harmful to the public's esteem of the judiciary, her conduct is prejudicial to the administration of justice, and discipline regarding these counts is authorized under the Georgia Constitution. So we've talked a lot about ex parte in the YSL trial and what type of violation would actually raise a red flag with something like the Judicial Qualifications Commission and the Supreme Court of Georgia. And here we're seeing that even something in good faith is considered a violation. So now I want to talk about how we're getting to removal for Judge Christina Peterson. With Judge Glanville, we have several attorneys filing motions to recuse, not remove entirely as a judge across the board, but these individual actions are recuse this judge from this proceeding, this specific proceeding. And what we're looking at with Judge Peterson is not a complete parallel. Yes, it's a judge. Yes, the state is Georgia. And yes, something improper involving an ex parte meeting was in play at somewhere. But with Christina Peterson, there's multiple charges here, and it's been determined that multiple charges warrant punishment. So what does the Supreme Court say about their decision to punish Judge Peterson with removal, with this order to remove her from the bench? So the hearing panel noted in its report and recommendation that the violations at issue here, when viewed individually, likely would not warrant the sanction of removal from office. We agree. The hearing panel also determined that Judge Peterson's misconduct related to the contempt matter was troubling and discordant with one of the judiciary's primary purposes, to provide due process to all who come into court, especially when one's freedom is at stake, and that her pattern of misconduct related to the many other matters exhibits a persistent unwillingness to apply herself the rules that apply to everyone else. But they do highlight 4 incidents that they think are very interesting. And one of those incidents was this ex parte meeting. So, they say, and although Judge Peterson possibly acted in good faith by permitting the ex parte communications with respect to the petition for years' support, her misconduct demonstrated a failure to comprehend and follow the law, which in turn causes prejudice to the administration of justice. As the hearing panel determined in recommending her removal, Judge Peterson's misconduct has already demonstrably eroded the public's respect for the judicial system, and regardless of the extent to which the hearing panel considered the mitigating evidence that Judge Peterson offered at the hearing, and emphasizes again before this court, we conclude that such evidence is not particularly persuasive, as the instances of misconduct at issue here spanned nearly the entirety of Judge Peterson's judicial career. The hearing panel's determination supported a conclusion that Judge Peterson was disingenuous, if not outright dishonest, during JQC proceedings, because she provided untruthful or evasive testimony with respect to, among other things, her conduct regarding the HOA meeting and the courthouse wedding. And importantly, they note that the hearing panel in this case found multiple instances in which Judge Peterson attempted to mislead the panel by falsely testifying, indicating her desire to conceal her misconduct. Because those findings are supported by the evidence at the hearing, we consider them as an aggravating factor in determining the proper sanction. So again, in conclusion, in this situation for Christina Peterson with the multiple violations, involving a combination of flagrant disregard for the law, court rules, and judicial conduct, patterns of violations, and her behavior during the inquiries into her conduct. All of that together is why the Supreme Court is concluding that removal is the appropriate sanction. And they're citing Fowler here, which holds that the removal from office was the appropriate sanction where the judge exhibited a, quote, consistent pattern of misconduct that stemmed from willful misconduct in office and conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. They also bring in from a different inquiry, which determined that removal from the office was a proper sanction for a judge who, among other things, demonstrated a lack of competence in the law, failed to safeguard basic constitutional rights of litigants, and failed to respect and comply with the law with respect to multiple matters of misconduct. And noting that, considered in isolation, none of the judge's actions would warrant his removal from the bench, but that considered as a whole, the judge's actions demonstrated a troubling pattern of ineptitude and misconduct. In another matter of inquiry, it was concluded that removal from office was the appropriate discipline for a judge who violated multiple former canons of the prior CJC, including in 5 instances disregarding defendants' basic and fundamental constitutional rights, which exhibited an intolerable degree of judicial incompetence and a failure to comprehend and safeguard the very basis of her constitutional structure. So accordingly, it is ordered that Judge Christina Peterson of the Douglas County Probate Court be removed from office, effective upon the date of this opinion. As a result, Judge Peterson, quote, shall not be eligible to be elected or appointed to any judicial office in the state until 7 years have elapsed from the date of this opinion. And all justices concur except for Colvin J., who was disqualified from this decision. So again, guys, this was an 80-page decision, and I apologize for summarizing all of the things that they weighed as a whole, because it's an important element that they weighed all of the charges as a whole in making this decision, agreeing to order the removal of Judge Christina Peterson. There were multiple charges over a span of time that the Supreme Court looked at based on the panel's hearing, the hearing panel's report and recommendations. And looking at all of that, they said, all of this considered, we agree that removal is warranted. Now, what do you guys think about that in isolation? What's going on with Judge Christina Peterson? And again, all of this was separate from the criminal charges that she's currently facing from the arrest a week and a half ago. Now, after you think about what you think about this in isolation, what kind of takeaways can we get from this as it relates to Judge Glanville and the YSL trial? So can we argue that it's a consistent pattern unless we have other inquiries on the table about Judge Glanville somewhere else? And if the Judicial Qualifications Commission decides to start an inquiry, how long will that take? Because what we're seeing with Judge Christina Peterson, they started to do something back in 2021, and they delivered their report and recommendations in March of this year to the Supreme Court of Georgia. And really, guys, I have so many thoughts. I really do. And it's interesting, with the criminal side of things, there's certain constitutional rights that are afforded to defendants. But at the same time, misconduct in the civil realm has egregious implications too. And it's really interesting here. It's why I wanted to do this video so badly, even though I'm focusing on certain parts of this ruling, is because we're getting an inside peek into how the Supreme Court of Georgia looks at things like ex parte communication violations by a judge, how the behavior, possible denial, or consciousness of some wrongdoing that's being denied, or there's an air of dishonesty coming from a judge about something that they did or partook in. All of that is really interesting to me in relation to everything we've been talking about in the YSL trial with Judge Glanville. And we didn't get into it too much in this video, but one of the other things that they focus on in this decision to order the removal of Judge Christina Peterson, is that she held someone in contempt and sentenced them to the maximum incarceration period affordable. And the Supreme Court didn't like that either. And the Judicial Qualifications Commission, the hearing panel, didn't like that either. So there's a lot of these overlapping layers, even though we're dealing with civil versus criminal. And my brain is going in multiple directions, wondering, well, if they're deciding to remove her, and right now, the issue with Judge Glanville is largely centered around a request to recuse from the instant case, the YSL trial itself, step down from that case. And if we're seeing here that the Supreme Court considered consistent patterns of behavior as an aggravating factor to rise to the level that warranted a removal of Judge Christina Peterson, is that something that could be argued about Judge Glanville? Will there need to be instances of misconduct in cases separate from the YSL trial to get this to rise to such a level? And I'm not sure, especially since we've heard that some people that practice in this area are quite confused and shocked by this behavior from Judge Glanville, saying that it's not really like him. Is there an expansive, consistent pattern of behavior spanning his career? Will we find that? And is that necessary for the Supreme Court to want to issue some kind of punishment like a recusal or removal? Could it be argued that since the YSL trial is so long, that that's long enough to say, hey, even if his misconduct is constrained to the YSL trial, that's enough months, it's more than a year, that should be considered a consistent pattern? Additionally, what will the Supreme Court think about his demeanor when he's faced with motions to recuse, how he responds to the attorneys that request as much, how he's navigating things like the show cause hearing or requests for transcripts about the ex parte meeting? We see in this ruling with Christina Peterson that the Supreme Court didn't really take well to the idea that she was denying or trying to possibly be dishonest about certain things that she did or said. And we also see some mention in the case law about incompetence being a problem as well. And it's my guess that the attorneys associated with the YSL trial, whether they're representing a defendant or they're representing, Brian Steele or Kayla Bumpus, or they're just part of the Gactyl strike team, those attorneys that showed up in full force, they're probably looking at the Supreme Court ruling, looking through it. They're going to look at the cases that they're citing, and they're going to see if those same cases apply to the situation at play for Judge Glanville, for everything that Judge Glanville's doing. So how parallel is the circumstance here when we compare the complaints against Judge Christina Peterson to Judge Glanville? Well, that remains to be seen. And how quickly will the Supreme Court be making a decision like this? We know that some of these attorneys are out there asking, there's urgency here. Like, hear this, listen to us, Supreme Court, hear us out, let us make our arguments to you on why Judge Glanville should recuse himself. And it's possible the Judicial Qualifications Commission already has something in motion on their own. They're doing their own inquiry. And with time, they may be able to produce their own findings and recommendations to help supplement something that the Supreme Court may already be considering. So really, really fascinating for this type of decision to come down right now in the midst of all this stuff with the YSL trial. And it's important for us to remember it's not exactly the same scenarios on both sides. But where there is overlap, I'm sure the attorneys that we've seen, the Georgia Association of Criminal Defense Lawyers, their strike team, I'm sure they'll find those arguments. I'm sure they'll find those overlaps, and I can't wait to see their arguments if that day comes. Let me know any and all of your thoughts. Again, full ruling in the description because we weren't able to address all the pieces and components of it in completeness. So that's there for you guys. You guys let me know your thoughts in the comments or in the chat. Hit the like button, and you guys all take care. Thanks so much for tuning in.